Welcome everyone to this webinar about police powers and your legal rights. Thanks very much for giving us your time and joining us this afternoon or nearly this evening. My name is Samantha Lee. I am the solicitor with the Police Accountability Practice at Redfern Legal Centre. I'd also like to thank DLA Piper, who has helped us with this webinar and is helping behind the scenes this afternoon. I'd firstly like to acknowledge the Gadigal people of the Eora Nation and pay my respects to elders past, present and emerging, and thank them for the land that I am sitting on at the moment. This webinar is being recorded and is being live streamed for you to know and be aware of that. We are taking questions throughout the webinar and you can put those questions within the Q&A forum of the webinar that you see. Any questions that you put there will be visible, so you are aware of that as well. Now I'd like to introduce our speakers, but firstly I'd like to say I really want this to be a practical webinar that gives people an understanding of their legal rights when they attend protests or are considering attending a protest, and help you to understand the limitations of police powers in regards to attending a protest. So we have a variety of really expert panelists this evening. We have Barrister Felicity Graham. Welcome, Felicity. Felicity is a lawyer with Blackstone Chambers, is a former trial advocate for the Aboriginal Legal Service. We also have Jane Sanders. Welcome, Jane. Thank you.
Sorry.
Jane is the, hello, principal lawyer and founder, the principal solicitor of the Shopfront Youth Legal Centre and has been working with youth for many years now, and it really is an expert in that field. And we also have Peter O'Brien. Welcome, Peter. Thanks for joining. Peter is the principal lawyer and founder of O'Brien Criminal and Civil Solicitors and has been doing some work in this area of protest for some time as well. Joining us soon will also be Professor Simon Rice. Some may be aware, hello Simon, that Simon was recently involved as an observer in a protest and was caught up in police powers, and will share his experience and some insights in regards to a most recent incident. So thank you, Simon. Okay, so let's just get into the questions. Firstly, a question to you, Felicity. COVID, we've had lots of police powers emerge due to COVID and public health. The orders have changed significantly over time. It's been really hard to keep up with these orders. So give us a rundown on the latest order regarding protesting, and does this new order allow for protesting?
Thanks, Sam. Since Monday, the 7th of December, so Monday just passed, a new public health direction was handed down by the Minister for Health, which concerns outdoor gatherings. And under that public health direction, it really depends on the numbers that you're talking about in terms of how many participants you might have at a protest. So the starting point is if you want to hold a protest that you're expecting will be under 100 people, or indeed is under 100 people, then the public health direction permits that type of event to go ahead. Indeed, any outdoor gathering of people for any purpose under 100 people is allowed under the current public health direction. If you're talking about a number over 100 and under 3,000, then there's a specific regime that the new public health direction now recognises specifically for outdoor protest activity. And I'll go into a bit more detail, but basically that type of event requires an organiser to register a COVID safety plan through the New South Wales Health Department online. on their online portal. And there
that's
are
quite a
certain
detailed
requirements.
plan, isn't it? It requires a number of things that people have to abide by.
That's right. And the four main topics are the well-being of people who are attending, either as volunteers or participants, physical distancing factors, hygiene and cleaning, things like having hand sanitizer, encouraging people to bring their own water and food and so on, and then record keeping. And I can go into a bit more detail about the practicalities of what you would actually need in your plan. But let me just give you two other categories in terms of how the authorization process works and how you can hold a lawful or authorized public assembly or protest. If it's over 3,000 people that you're talking about, under the current public health direction, that would not be permitted, but there is the possibility that you might still be able to hold such an event if it were authorized by the Supreme Court or the police. And there's a possibility that immunity from the Public Health Direction could be obtained through that Summary Offences Act process, which organisers might be familiar with, is called a Form 1 process. And then if your planned event, whether it's under 100 people or over 100 people, involves wanting to march on a public road or block off footpaths, then in addition to your COVID safety plan and complying with the public health direction, you're going to need authorisation under the Summary Offences Act to give immunity from offences such as blocking traffic, things like that.
So Felicity, can I just ask a specific question in regards to that? If someone does get a Form 1 permission to hold a protest, you did mention immunity. What does that protect protesters from?
So ordinarily that will protect a participant in a protest from liability for criminal offences arising out of anything that they do or don't do for the purpose only of participating in that protest or that public assembly. Ordinarily, we're talking about things like obstructing traffic, obstructing pedestrians in a public place. But there have been some cases this year that have looked in the Supreme Court at whether or not the immunity under the Summary Offences Act, if you get permission from the police or the court to hold a public assembly, whether that also extends to immunity from criminal liability for breaching a public health direction. There's some perhaps lingering controversy in the courts about that. It may be yet to be resolved finally, but there's a Supreme Court decision in Taylor Gray's case of Justice Adamson where Her Honour determined that the immunity did flow to a breach of the public health direction.
Thank you. Might leave that question there. We do have a question from a participant about move on direction. I might hold that for a minute and get back to that question. Jane, I might just go to you quickly and ask you about police asking protesters for their name and a copy of the ID. What rights do they have to ask protesters, one, for their name and address, and two, for a copy of ID?
Okay. Firstly, police have got the right to ask anyone for their name and address or their ID anytime they want. The question really is, do people have to provide it? So, and I think that's an important distinction to make because police rely a lot on people's consent. What they're relying on is people's ignorance of their rights. So police will ask people for ID. People think, oh, police officers asking me, I have to provide it, better provide it. Police then go and do checks on the system. They decide that then they're going to search you, whatever. So there's nothing special about protests which gives the police any extra power to demand name and address. There's a whole range of situations in which you are required to give your name and address if asked by the police. There are too many for me to list them all right now, but examples include if the police actually do suspect on reasonable grounds that you've committed an offence and they want to give you an on-the-spot fine, for example, or a court attendance notice without having to arrest you and drag you back to the police station, they want to verify the identity of the person they're giving the fine or the notice to, so that they make sure they're issuing it to the right person and you're not just posing as your sister or your cousin or whatever. Other situations are, for example, if they suspect on reasonable grounds that you're a witness to a serious offence, such as an assault or something like that, because you're in the vicinity where the offence occurred. Other situations are, I think, if they suspect you of being under 18 and possessing alcohol in a public place. There's a whole range of them. In most of those situations, you may be required to give your name and address. They have to warn you that this is a situation where you have to provide it. So if you say, no, I'm not telling you anything, they have to warn you that it's an offence not to. Now, in almost all of these situations, they can ask you for ID, for documentary ID licence or proof of age card, but in most of these situations, you don't have to provide it. We haven't got to the point just yet, at least, where people have to carry around ID cards all the time. The exception is traffic and driving, where if you're driving a motor vehicle, you have to carry your licence around all the time. That would be the main exception. Also, if you're travelling on public transport on a concession fare, you have to carry around your concession card with you at all times, and that's a form of ID as well.
All right, thanks very much, Jane. Peter, over to you. When can police arrest you, or under what circumstances would police have the power to arrest you at a protest?
Well, the answer to that comes down to whether or not the protest was authorised in terms of the things that we most commonly consider in terms of available police powers. So so Felicity talked about whether a protest is authorised or unauthorised, and that comes down to the Part 4 of the Summary Offences Act and whether there's been a Form 1 either granted by the police or allowed by the Supreme Court. Now, if a protest is authorised, police don't have the power to make move-on directions. And as Felicity said, there's also immunities from obstructing traffic type offences as well. But obviously, if police suspect reasonably that you have committed an offence and it's reasonably necessary for a variety of reasons to arrest you, then they can arrest you. But they can't do it because you're obstructing the traffic, and they can't give you a move-on direction if it's authorised. So the authorisation really protects you from offences such as failing to comply with the move-on direction. Now, if the law actually says you are entitled to protest, so genuine protests or apparently genuine protests or assemblies or demonstrations are totally lawful. And if it's a lawful protest that's not affecting traffic, and it's, so for example, it's in a park or outside a town hall or on a footpath, and it's not risking anyone's safety, police do not have the power to issue a move on direction, and they don't have the power to move you on or arrest you for being part of that protest unless they see something unlawful occurring. Now, if it is an authorised protest, if it's an unauthorised protest and it spills onto the roadway, the police may give you a direction to move off the roadway and allow vehicular traffic. And if they do that, there's certain things that they need to do. As Jane said, they need to give you, first of all, a direction to do it, and they need to tell you that the direction needs to be complied with at law, and the consequences might be that you may be arrested if you don't comply with it. So there needs to be a warning of that type. They need to identify themselves as police officers, state their name and place of duty. And if that direction is given and you still stay where you are, they may choose to arrest you. And that failing to comply with the move on direction is only a fine only offence. So they might simply choose to give you a fine. But if you stay where you are and you don't comply with that move on direction in an unauthorised protest which is spilled onto the road, then you risk being arrested, because they would say it's reasonably necessary to prevent the repetition of the offence. That is, you're going to stay where you are and not comply with another move on direction. So
how long after being given a move on direction do you have to move?
Well, first of all, the move on direction needs to be a reasonable one. It can't be. Recently, there was a protest at the end of a cul-de-sac where there's no traffic at all, and people were told to move off the road. The question was it truly necessary to move in that space where they were genuinely protesting a political action at that particular site? So it has to be a reasonable move on direction. And similarly, if you haven't complied within a matter of moments, that wouldn't be necessary. You have to show under the legislation. I'll just go to the terms of it. They have to show that you've that the failure to move on. Police may. You're not guilty of failing to comply with the move on direction unless it's established that the person persisted after the direction to engage in the relevant conduct. So you have to persistently be there. It's not sufficient to say, okay, I've asked you to move on. That's enough. Off you go. You're under arrest.
Obviously, that doesn't happen much in practice, though, Peter. Police seem to be very quick to arrest after being given a move on direction.
Yes, and if you can demonstrate that you won't give an opportunity to comply with the direction, you should plead not guilty and you should be acquitted.
Mm-hmm. Okay, this might be a good opportunity to move to Simon Rice, Professor Simon Rice, who was recently arrested after being an observer at a Sydney Uni protest in regards to education. Simon, maybe if you give us a brief rundown about the incident and also some insights that you've had since this incident for people that are thinking of protesting or have been at a protest. You're on mute, Simon.
You'd think after a year of teaching on Zoom, I would have learnt to switch the mute off. Thanks, Sam. Yes, I was observing the protest because, as it happened at the same time, I was teaching law reform and social movements and so on, so it was relevant. And as the journalist took delight in the irony of the fact that I was teaching protest and ended up involved in one, I was watching. I got too close. The police grabbed me from behind and marched me along for about a few meters, and while I was turning to ask them why, they kicked my legs out from underneath me and I fell to the ground, and I instinctively went to get back up again and they went to push me back down, which is what the viral video shows. And then I sat on the ground, and pretty much as Jane described, I didn't argue with them when they said, "What's your name? Show us your ID." And I had no reason to argue with them, so I told them my name and I showed them my ID. I asked what I was being charged with, because I understand that an arrest indicates an intention to charge. I know that's not necessarily the case, but at the time that was my thinking, and I was told I wasn't going to be charged with anything, I'd be fined, and then I was told to leave, and I did. So that's what happened. It all happened quite quickly. A couple of quick reflections. One is, and I've a few reflections, and some of this I've written about people that might have read. One is that what happened to me is what happens to people every day, all the time, all around Australia. They're Jane's clients, they're Felicity's clients, they're Peter's clients. If they hadn't picked on the grey-haired bloke in a suit who happened to have been a professor, then no one would have known about this. We wouldn't be having the same discussion. It's just that it was fairly shocking for my peers, for people who live my comfortable middle-class lifestyle, to discover that this can happen to one of them. So a reflection is just what a limited view a lot of us have of the world that many of us live in. Another reflection was the speed and ease with which the police acted with aggression and violence. It was very disconcerting to see a peaceful protest set upon like that. And that, of course, leads me to reflect on what it is about policing and the environment, where the direction comes from. The next day in my class, not surprisingly, my lesson plan went out the window, and the students wanted to debrief on this. And they kept saying, the police this, the police that, the police this. And I said to them, look, it's not a monolith. There were police officers there. They behaved in a way that I assume they felt they were able to behave. They felt that they weren't going to get into trouble for doing what they did. So when we talk about the police, I think we need to talk about where the direction or the ethos or the idea comes from the minister down to the police in the front line. We need to look at where the power lies and where the authority lies that we're actually scrutinising. And then I could go on, but just one final reflection, which has come from my experience since. I wasn't aware of just how unaccountable police are. I wasn't aware that there is no independent oversight of ordinary police conduct unless you can get over the threshold to get a complaint considered by the Law Enforcement Complaints Commission. That I either ask the police to review themselves or I make an allegation serious enough for the commission, and in between there's just nothing. The onus is on me to pursue a common law action. The onus is on me to go and seek freedom of information documents to find out what kind of complaint I could make. And the onus is on me to try and articulate an argument that the police will take seriously. And this massive gap of absence of independent oversight makes me feel very exposed, and I'm one of the most capable victims you could have. So heavens knows what it's like for most people.
Yes, thank you, Simon. I think you've given us your story that demonstrates that it's not easy to assert your rights. There is a huge power imbalance in these situations, and even people that have information in the circumstances in the moment, it's a very difficult and overpowering situation. So thank you for sharing that with us. I might move on to Felicity in regards to building on Simon's situation where he was issued with a COVID-19 fine. Before the laws changed regarding protesting, people have been issued with COVID-19s for a range of matters. What options do these people have?
So Sam, the first option, I guess, is just to pay the fine, the $1,000 fine. That is a penalty notice. It doesn't amount to a criminal conviction. It's similar to other types of fines that you might get in terms of the consequences ongoing for you. Second option might be to apply for an internal review through Revenue New South Wales. That can be done online through the penalty notice part of the Revenue New South Wales website. Although I can say that for protesters who have faced fines arising out of COVID-19 breaches in the last 9 months or so, that hasn't been a fruitful avenue for people who've pursued that path so far. The third option is to elect to take the case to court, to the local court it would be, and that then is processed as criminal proceedings before a magistrate. And I suppose the two things you might be trying, one of two things you might be trying to achieve out of that process is, first of all, to admit the offence but seek leniency by way of a non-conviction order so that you don't have to pay the $1,000 fine. And a non-conviction order would mean that there'd be no financial penalty. Or the other outcome that you'd be seeking would be to plead not guilty and actually persuade a court that you are not guilty, and then ultimately succeed. Importantly, in the context of people fined for COVID breaches at protests, that public performance of political expression at a protest, I think really engages this part of the offence provision in the Public Health Act in section 10, where a reasonable excuse is a carve-out exception to liability for failing to comply with a ministerial public health direction. And there are some kind of different legal issues that are going to come up, but it seems to me that that is one mechanism through which the right, if I can sort of put that in inverted commas, to protest in New South Wales could be given effect to. There's a question about whether the former public health directions are constitutionally valid in terms of the way that they interact with the constitutional principle of the implied freedom of political communication. But one way that might preserve validity of the public health directions as they previously were in terms of capping gatherings at 20 people and not having a regime which accepts public protests where soccer and the casino and whatever were, the pub were exceptions. One way of preserving validity might be the courts might recognise as through this reasonable excuse provision. So that's something that might be available to people who were participating genuinely in a political protest, particularly if they were participating in a protest where they were otherwise taking steps to be COVID safe. So maintaining physical distancing and putting in place other steps to keep themselves and others safe, like wearing a mask, using hand sanitizer, etc., etc.
Felicity, we had a question in, is can a government employee engage in protests without losing their job? Do you want to say anything about that?
Others might have a view on this as well. I was asked a similar question at a recent Aboriginal Legal Service webinar on protests in terms of whether public servants can speak out about their political views. I think it's a bit of a complicated area. I wouldn't want to give a kind of final view on it, but I think taking on a public servant role comes with some constraints. Others might, Jane or Peter or Simon might have something to say on that as well.
No. Okay. Jane, one for you. You're really a specialist in young people and the police. If we have someone at a protest who is under 18, are there special rights that young people have in regards to police powers?
Yes, there are, with some police powers for sure. Unfortunately, young people under 18 can be arrested, stopped, searched, moved on pretty much like adults can, but there are some limits. Peter was talking about arrest a few minutes ago and how arrest has got to be reasonably necessary. So it's not just about the police suspecting you've committed an offence, but they have to really need to arrest you, for example, to stop the offence continuing or stop you running away or whatever. That idea of arrest as a last resort is all the more important when it comes to young people. When it comes to police asking questions of young people, so we're talking about young people who are suspected of a criminal offence, there needs to be an adult support person with them. Otherwise, anything they say to the police is almost always going to be inadmissible in court. So whatever they say can't be used against them. Now, obviously, if police come up to a young person on the street, there are no adults around, police are allowed to ask the young person preliminary questions. That's fine. But if the young person admits to an offence or something that incriminates them, then in order for that to be used against them in court or whatever down the track, police have got to show that there's a proper and sufficient reason for an adult not being present, and that in all the circumstances it's reasonable to allow it in. So what the police often do, and again, this is a trap and a trick and something that young people should watch out, or their adult support people should watch out for. They ask the kid all these preliminary questions. The kid says blah, 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 blah. Then the police wheel them into an interview room at the police station. They bring in mum or dad or auntie or youth worker or whatever and ask them all those questions again. The young person thinks, oh, well, I've already told them all of this, so I'll just confirm it. But now it's admissible because there's an adult there. So that's just an example, I suppose, of how that sometimes plays out. Another protection that young people have, at least in theory, although not in practice so much, is with searches. And that a young person is, and Sam, I know this is something you know all about, a young person is supposed to be able to have a support person present during a search, a parent or guardian or someone. That is particularly so if the police are going to be doing a strip search. Now, there are lots of limits around strip searches for adults or children. Police are only allowed to strip search if they, I can't remember the exact wording now, but if they believe on reasonable grounds that the strip search is necessary for the purpose of the search, and also that there's urgency associated with it. If they do come to that view and decide to do a strip search, as well as giving people the rights to privacy and whatever, somebody who's under 18 is entitled to have an adult support person. But of course, if the police think it's really urgent and they need to do the search immediately before a support person can get there, then they can do it without a support person.
So Jane, both you and I know that support persons aren't always brought in. What's something a young person can say to police if they know that they are required a support person? Just a bit of a script. What's something they could say to police to try and get that support person present?
It's very difficult because some police officers will take notice. If it's obvious that a young person knows their rights, they might back off and say, oh, whoa, okay. But sometimes that will just antagonise the police and they'll say, don't you be a little smart ass with me. I don't know if I can suggest a script, but maybe Felicity or Peter might be able to suggest something as well, but just, I'm under 18, can I have a support person? I need a support person. Can I call my mum or something like that? I don't know that there's much else I can suggest because every situation with police is dynamic. Things often unfold really quickly. There's a big power imbalance. So it's really hard to advise young people what to say, but maybe just, I'm under 18, can I have a support person?
Yeah, thanks, Jane. It is very difficult. Peter, I want to move on to the use of force and protesting, because it's something that does come up a fair bit. Well, firstly, let's consider when police can use force and how much force they can use. And a question that follows on from that is, if you resist that force, what happens, or can you resist that force? Oh, you're on mute, Pete.
Sorry. So the answer depends on whether or not a police officer has determined to arrest you. If they have determined to arrest you and the arrest is a lawful one, they can use a reasonable amount of force. So force that's reasonable in all the circumstances. If they haven't determined to arrest you and you're not in the process of committing an offence, they can use no force at all against you. It really comes down to that. Now, it was never advisable if a police officer is determined to arrest you and therefore use force, and that might be simply the touching of your arm or the grabbing of you, right through to the full apprehension, the use of weapons, the use of spray, the use of handcuffs. All of that, it can be considered a use of force. It has to, in all circumstances, be reasonable to the manner in which you're conducting yourself, and to the circumstances in which the police are presented when they use the force. But if the force is being used against you, it is always advisable not to resist. Always advisable not to resist, because that will lead to the increased use of force against you, and it might result in injury. Now, best always avoid it. However, if a police officer is using unnecessary force or is not entitled at law to arrest you, you are entitled to defend yourself at law. So that would mean that the police officer is not acting in the execution of their duty, which is a necessary ingredient for the offence of resist arrest, and would mean that the arrest would be unlawful, and any subsequent resist to that would be also unlawful, because the police officer wasn't acting in the execution of their duty or their lawful duty. So it is always advisable not to resist arrest, even if you believe that the police officer does not have the power to use force against you. And the answer to the first question as to whether a police officer can use force is only if it is necessary in all the circumstances. And that's always going to be something that is looked at in hindsight after that has all happened. So most importantly, if you're determined to resist, it really must be because you're defending yourself against an unreasonable, excessive amount of force, and that'll be something that's judged by a court, probably down the track, whether that's in the civil or criminal jurisdiction.
So we have a question about handcuffs, Peter. When are police entitled to use handcuffs?
Well, again, it comes down to the question of whether it's reasonable in the circumstances. Whether if a person were flying their arms about and, for example, attempting to strike at the police officer who's attempting to subdue and arrest them, then arguably a police officer would be entitled to use handcuffs. But otherwise, it's not. It has to be reasonable in all the circumstances, and that will vary and depend on each of the circumstances. But it's certainly not the case. It's certainly not the case as some police officers believe it to be. You arrest every person that's handcuffed. That is not the law. It's never been the law, and it's simply the handcuffs are an implement that appeases and reduces the risk to police and to others around, and it is in essence an instrument used in the application of force by police. So it has to be reasonable in all the circumstances.
So just following on from there, Peter, I recently, this year at the Black Lives Matter protests, police at a later stage in the protests, when it moved to Central Station, police used capsicum spray. Before, though, using capsicum spray, they used a technique called kettling. Can you explain to participants what is kettling and your thoughts about the use of this technique?
Yeah, I hadn't actually come across it before the Black Lives Matter protest that took place early this year, and then police used this technique in and around Central Station. But it's basically a technique whereby police trap people in one spot. Essentially, they surround people that they want to detain, or in this case, they were trying to disperse them, which was quite ironic. But they either to detain or disperse and slowly move in on them, so that people are trapped in one area. The really troubling aspect of how it's happened, both in Melbourne more recently, associated with some of the anti-lockdown protesters, and indeed anyone who happened to be around them, even watching them or in the vicinity, and also at the Black Lives Matter protests in Sydney earlier, was that it put people in a position where they were more at risk and more vulnerable to exposure to COVID-19 if it had been transferred by any particular people. So it is a lawful technique, but it has tremendous risks associated with it. Now, what it also and I think it's fair to say that it can be dangerous, particularly in the pandemic type scenario. But what also it represents is a form of imprisonment. And I think this is where police have got to be very, very careful in applying this technique, because if there are people who are lawfully present or are trying to move from that area to another and are prevented from doing so because of the kettling technique, they may well have, for example, civil actions for unlawful imprisonment on their hands if they engage in this particular policing manoeuvre. So it would suggest, my suggestion is that it's more harmful than useful, even for police, but it has enabled in the Black Lives Matter protests for people to then be sprayed in concentration with capsicum spray, and in the in the anti-vax, anti-lockdown protests in Melbourne, it enabled police to pick people out one by one, arrest, charge, or provide them with infringement notices. It's a disturbing development in policing, that they're using it, and I think it's even more disturbing that they're using it in these times with COVID-19. It's very troubling.
Yes, thank you. It's a really good rundown, and it was disturbing to even just see the images. Felicity, I'll just move on from there in regards to Aboriginal and Torres Strait Islander people. If you could just used to work as an advocate for Aboriginal Legal Service, but if you could just point out some of the specific legal rights Aboriginal and Torres Strait Islander people have in regards to police powers. And I might add an additional question onto that. If you could tell us the powers police have in regards to offensive language.
Yeah, sure. So in terms of special rights that Indigenous people might have vis-a-vis police, that really operates in a scenario where police have arrested an Aboriginal or Torres Strait Islander person, and particularly where they've arrested them for an offence, which then gives rise to that person being in a particular status in a police station, which we call Part 9 custody, which refers to Part 9 of the Law Enforcement Powers and Responsibilities Act. And if a person is in a police station in that situation, then certain protections flow in recognition of what Parliament has deemed to be the vulnerable status of an Indigenous person in custody. There are other people that fall into that vulnerable status, people with an intellectual impairment, people who are children. There are a few different categories, but Aboriginal and Torres Strait Islander people fall into that category. Some of the things that then flow from that vulnerable status include, for example, a requirement upon the police to notify the Aboriginal Legal Service that they have that person in custody, and that then provides an opportunity for the person to have access to a lawyer. The Aboriginal Legal Service provides an around-the-clock telephone advice service to all Aboriginal and Torres Strait Islander people taken into police custody in New South Wales and the ACT. There are similar regimes in other jurisdictions, but I think the New South Wales ACT custody notification system has been a very successful one and a very across the board in terms of the implementation of it. Some of the other jurisdictions have pretty patchy implementation. And that then gives, I guess, the chance for two things to happen. One, for a lawyer to give them some legal advice about their right to silence, whether any forensic procedures are going to be performed and their rights in that regard, but also to do a welfare check on the person and ask them whether they're injured, whether they've been treated poorly by police and things like that, and also to facilitate one of the other rights that arises, which is a right to a support person when dealing with the police, particularly when dealing with the police in any kind of interview scenario. So they're the main kind of protections that flow for an Aboriginal person in police custody. Quickly then coming to that second question, which was about offensive language. If you are participating in an industrial dispute, an apparently genuine demonstration or protest, a procession or an organised assembly, then police cannot issue you with an on-the-spot fine, or what we call a penalty notice, for offensive language. That is a sort of prohibited procedure. It doesn't mean you can't be charged with such an offence, But if you've been issued with an on-the-spot fine for offensive language, then that's an invalid penalty notice. And if you apply for internal review through Revenue New South Wales, it should be withdrawn. Now, in cases where that has happened, that has resulted in the police turning around and actually charging the person and taking that person to the local court to face offensive language as a criminal charge. But I might just say something also as a bit of an aside, because this is, I think, an area that needs a lot of attention and is an area where there could be some really powerful reform if the right litigation comes along, because there remains an outstanding question whether the crime of offensive language is actually constitutionally valid. In other words, whether it is actually a valid offence at all, whether it's known to the law. And so anyone charged with an alleged crime of offensive language should really lawyer up and get some advice about whether they have an available defence based on a constitutional challenge, particularly if her fact pattern involves participation in a political protest. There have been certain cases where this issue has arisen, but it's either resulted in protesters being found not guilty or the police withdrawing the charges. So it hasn't kind of fed through the court system for it to be determined at a higher level. And I think it's really important because we know that offensive language, or rather swearing at police officers, is a mechanism that's used by police, or it's a device where that scenario happens. The police use it as a device to escalate a situation, often use force unnecessarily, often escalate a situation to a point of arrest. And that affects disproportionately vulnerable and marginalised people in our community, particularly Indigenous people and particularly young people. So, I mean, if there's anyone out there who has been charged with offensive language, they could be part of a really powerful reform to take that legal point and take that offence on.
Interesting. Yeah, I hope someone takes up the offer and lawyers up and tests that area of law. Jane, I want to ask you, which is coming up a lot on our questions, is about filming police. Can people film police when they're at a protest? And the other question is, can police film you?
Yeah, the answer to both questions is yes. We have no property in our own image. So if anybody who is in a public place, you can lawfully film them or photograph them. There are some restrictions on recording sound, but only if it's a private conversation, if it's circumstances in which the person would reasonably expect privacy. So if you're having eavesdropping on a private conversation in somebody's lounge room and you're sort of standing outside the window and recording it without their knowledge or without their consent, that would be an offence. Recording sound in a public place at a protest with protesters talking to each other, police talking to each other, generally is perfectly legal. I suppose if a police officer had somebody under arrest and had them in a quiet corner and was asking them some questions in a situation where clearly they're trying to keep that quiet and confidential and away from the public, you could film that interaction, you could photograph that interaction. Perhaps if you got too close and you recorded the sound of that conversation, maybe that's coming close to being a private conversation. But generally, yes, you can film, you can photograph, and also you can record the sounds as well. Can the police film you? Well, yeah, they can. If you're in a public place. Some limits on that, and I think maybe this is common sense, like upskirting, for example. There are restrictions on filming or photographing people in an offensive way for sexual gratification, but generally, yeah, they can film you if you're out in public. What use can the police make of that? Can they take your photos if they want to just go around going snap, 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 snap? They certainly can take photos of anyone in a public place, but they can't make you stop and pose for the photo. And I think that's a different thing. That's a distinction. It's a bit like asking for your ID versus you having to provide it. Because what the police often do is they come up and talk to people, usually young people, or maybe it's protesters, or maybe it's people who are lining up to get into a venue and the police take the sniffer dogs up and down, and then they might decide to take photos of people as well. If they basically try to line you up against a wall to take a mugshot or tell you, hey, you have to stop here or look this way so that I can take a photo or so that I can film you, that's unlawful. If they want to actually take a photo or film you in that sort of way, actually making you pose for it, Felicity knows a lot about this. Arguably, that's a forensic procedure and there are special rules about that. Or if they have you under arrest. So if they've arrested you on suspicion of an offence and they've ticked all those boxes that Peter talked about, the arrest reasonably necessary, blah, 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 they can take your photo back at the police station just like they take your fingerprints for identification. So, yeah, short answer, I suppose, and I could have given a much shorter answer, but the short answer is, yeah, generally anyone can photograph or film anybody else, but making you pose and making you stay there and be filmed or photographed, that's a different thing.
Peter or Felicity, do you want to add anything to that?
Look, only that I think filming interactions with police and recording what happened to them can be a really valuable tool to achieving accountability in terms of police behaviour. Sometimes because it can make police behave at the time, although a lot of occasions, you know, that's not the case at all. Police well know they're being filmed and they behave unlawfully and improperly. But secondly, because vindicating your rights vis-a-vis the police is a really difficult thing to achieve. And if you have the interaction caught on film, then you're in a much better position to be able to vindicate your rights either as a criminal defendant or as a civil claimant in some kind of tort action like false imprisonment or being assaulted by police. And my experience is that the types of situations where media attention is brought to bear because there's quite explosive video footage is just the tip of the iceberg in terms of the scenarios in which police breach the law and behave inappropriately towards citizens. And to the extent that more interactions can be recorded, I think it's a good thing.
Can I just add a word of warning that if you do film the police or some kind of interaction with police, the police have been known to confiscate people's phones. Now, the really dodgy, corrupt ones might be confiscating the phone to deleting the footage. The ones who are perhaps not quite that bad are confiscating people's phones because it's evidence of an offence. Now, I think I've written a whole paper about this if anyone's interested, but I won't go on at length right now. But I think the police are misusing their general stop and search power. So the police have got the power to search you if they suspect on reasonable grounds that you've got drugs on you or stolen goods or weapons or whatever. And if they find anything, the section says they can confiscate prohibited drugs, etc., or anything that may be evidence of an offence. Now, the police seem to think that that justifies them confiscating material from bystanders that may provide evidence of an offence. Can you imagine police just coming and forcibly confiscating, you know, ripping out the footage from the City of Sydney CCTV cameras or the CCTV camera in any servo or railway station or pub? No, they're not going to do it. Can you imagine them confiscating Channel 7's camera, right? They're not going to do that. There are proper procedures for obtaining footage and documents and other material. So the police really should have no business confiscating your phone. I mean, you eventually get it back months later once they can be bothered downloading the footage, but at massive inconvenience to yourself. But that's something just to watch out for. I don't think they've got the power to do it in that way, but they have been known to do it. Also, I guess if you get really close, if you come in really close to where the police are, they might accuse you of hindering them in the execution of their duties. So think about that as well.
Great, thank you. Okay, we've only got like 2 minutes left. I've got some quick questions coming through. So I'll just put it out to the panel to answer. Is it unlawful for police to hide their badges? Peter, I'll throw it to you. Unlawful to hide your police badge?
No, it's not. If they're exercising a power, they need to identify themselves and their station of work, and they need to give a reason for the exercise of power. But if they're not doing that, if they're just going about their ordinary duties, it is not necessary for them to display their badge.
Mm-hmm, thank you. And we've got a question about a move on direction. Felicity, in terms of move on directions, if it's given over, for example, a megaphone, is that an adequate direction, or does the direction have to be a one-on-one direction?
Might have to check the exact provision, but there's certain there's a broader scope for police to give directions to a group of people. Whether or not a particular individual in that group could be held liable for failing to move on, I think might depend on whether there could be sufficient evidence to show that they actually heard and were aware of the move on to be able to comply with it. But yeah, there are provisions in Law Enforcement Powers and Responsibilities Act that allow police to effectively give an en masse move on direction, and doesn't have to be to individuals.
Thank you. One last question. Peter, if something does go wrong and police act unlawfully or someone gets hurt, what can they do? Just a quick summary.
Well, if you're hurt, obviously you need to get, the best thing is, if it's something sufficient enough to go to hospital, obviously look after yourself and give a narrative to those treating you, whether it's paramedics or doctors. Give a narrative as to what happened, explain in as clear and concise details what occurred, so that can be recorded. A good doctor or a good paramedic will necessarily require that in order to provide the right treatment. It's also necessary, I think, to take photographs of that injury and have it properly documented. So if it's a type of injury, a scrape, a bruise, a cut that doesn't require medical intervention by a professional, then just make sure you've got it documented as best you can with photographs, video footage, and make a good record of it.
Excellent. Thank you, everyone. Felicity, Jane, Peter, Simon. It was a really worthwhile session. We've had lots of questions. We can't get to all of them, I'm afraid, but we'll run this webinar again, hopefully next year. Thank you, everyone, and especially to DLA Piper for hosting the webinar. Have a good evening.